Justice Alito?
Would you comment on Mr. Mupan's argument that a distinction can be made under his understanding of what the Secretary can do between pressure to get rid of a recommendation and pressure to adopt a recommendation in the first place?
Any kind of pressure, Justice Alito, is incompatible in our view with the statutory guarantees of independence. I don't see how that distinction can be reconciled with the text of a statute that not only guarantees the independence of the task force members and their recommendations, but also says that the task force and their recommendations has to be immunized from political pressure to the extent practicable. I just don't see how that distinction can be squared with anything in the text of the statute. I think what Mr. Mupan is trying to do is salvage some role for 299B-4A6, because it's not plausible, I think even on the government's view, to allow the earlier enacted statutes such as Section 202 and the reorganization plan to completely swallow up these later enacted guarantees of independence. So they're trying to draw some line, but there's nothing in the text of the statute that can provide an anchor for the distinction that he's trying to draw.
Suppose it is ultimately decided that the statute implicitly confers the appointment power on the Secretary, and that and then how much more of the statute would have to be jettisoned in order to make it constitutional?
I don't think
the setup constitutional.
Yeah. None of the statute needs to be jettisoned in order to make it constitutional, even under our reading of the statute. If the court decides that Congress has vested the Secretary with appointment power over the task force, the appointments are still unconstitutional in our view because they're principal officers. They have to be appointed by the President and the Senate no matter what. But if the court even rejects that view, there's still the problem that the task force was appointed by the AHRQ director for 13 years, between 2010 in March and June of 2023. And there has to be some remedy issued for those admitted constitutional violations.
So that would be for what was done before Secretary Becerra. What about going forward? What would need to be done?
Going forward, it will depend on whether the court thinks these are principal officers. If the court thinks they're principal officers, then they have to be appointed by the President and the Senate.
Suppose we thought that they were inferior officers.
If the court thinks they're inferior officers, there should be a remand in our view to the Fifth Circuit to rule on the question whether Congress has vested the Secretary of Health and Human Services with appointment power. I don't think it's appropriate for the court to decide that issue based on how cursory the briefing is.
Well, suppose we do that. The Fifth Circuit goes back and says that, or we tackle the question and we say that the statute vests the appointment power in the Secretary. Then what?
Then there has to be some remedy.
That's what I'm asking.
The remedy would have to be an injunction that restrains the Secretary from enforcing any of the task force coverage recommendations that issued between March of 2010 and June of 2023. Even the government concedes the task force was unconstitutionally appointed during that time. So I don't see how the government can deny that we're entitled to at least that much.
And what would be the remedy going forward if we went along that?
If the remedy going forward, if the court concludes that they're inferior officers and that the Secretary has been vested with appointment power, there should be no remedy going forward. We only can get a remedy for those past that 13-year window.
Thank you.